Friday.
Hello.
More people loading on. Going to be pretty quick today because it is beautiful out there, and you should all be out there doing site inspections for the managers. Your site inspections may even lead you to Martel's Tiki Bar. Just saying. It's a beautiful day, so I do hope you do get outside. So today we're going to talk about the mortgage foreclosure law, but today we're going to talk about revisit the Boyle versus Ocean Club Condo Association case, because the Supreme Court decision in that case came out this past week, and it is a huge decision, especially for Mr. Boyle. That's a hard day for Mr. Boyle. Hi, Donna. How you doing? I think I still owe you a call. But anyway, so we'll talk about the Boyle case, and also, as you know, I have to make my usual announcements. So these are for educational purposes only. There's no attorney-client relationship formed by them. This is not really legal advice. We're not giving legal advice today. There's no confidentiality. And if you need to have an attorney relationship, either reach out to us or reach out to another law firm and have an attorney relationship, and we'll send you a retainer agreement. So these are for discussion purposes only, but we really appreciate you coming. And thank you so much for coming. Thank you also for everyone I saw at the Cooperator show this past week. We wound up with a real nice turnout at the Meadowlands Conference Center up in Secaucus. And the Cooperator show was very good, and it was well attended this year. So we have the dog of the day. And the dogs, we have actually two dogs of the day. There are two dogs of the day today, and the German Shepherd on the left is Sierra, and the Husky German Shepherd mix on the right is Zoe, and they're beautiful dogs, and they belong to Victoria Mitten from Access Property Management. So thanks so much, Victoria, for sending in pictures, beautiful dogs, and there she is. Hi, Victoria. I think she's in the car. Hey, I hope you're going somewhere nice, like the beach or maybe Martel's. But it's good to see you, and thanks for sending them in. So we'll talk a little bit about board membership. Many of you are board members. Many of you are also management representatives. But for the board members themselves, it's often a thankless job, right? And unlike most of the people in the industry, you're not getting paid for it, right? So it's all risk and no reward much of the time. The reason you do it, right, is you care about your community. You want your community preserved. You want to have the lifestyle that you bought into when you purchased your home in the community. And most importantly, you want to prevent the wackos from getting control of your community and ruining it, right? Because everyone knows that every community, just like pi in geometry, has at least 5 wackos. That's a constant. That's a mathematical constant. And if you have vacant seats on your board, it's guaranteed that you will get a wacko, right? So it's very important that you run. It's very important for people like you that are serving on the boards to continue to serve on the boards, and don't throw up your hands in disgust like many people are today and walk away from board volunteering. The board members are what are saving the associations these days, and many boards are having a hard time getting candidates. So thank you to everyone who runs for the board. What is board member indemnification? If there was not indemnification for board members, none of us would serve on boards, right? How could you? Because if you served on a board and there wasn't indemnification, in theory, people could sue the association and sue you individually, and they would be able to reach your assets, take your money, take your stuff, take your house. So no one would ever volunteer for the board, okay, if there was not indemnification. And what indemnification says, basically, if you're acting in your capacity as a board member and you're acting in good faith, and someone brings a claim against you, and that person is successful and gets an award, you will be indemnified for that award. You won't have to pay it, but the association will have to pay it, or the association's insurance company will have to pay it. That's indemnification. In line with indemnification, right, is board member defense. And oftentimes, board member defense is much more important than board member indemnification. The reason for that is oftentimes the claims that are brought against board members, and I'm sorry, the board entirely, the association entirely, and individual board members have no merit. They have no merit. However, the attorney fees for defending the board members in the association can run into the hundreds of thousands of dollars. right? So that would bankrupt all of us individually if we were on boards as volunteers and we had to pay hundreds of thousands of dollars in attorney fees to defend ourselves because of our service on the board. Okay, so defense. Most governing documents provide for indemnification. If there is a judgment against the association and or you individually, it will be paid. And defense, attorney fees and cost for defending you as a board member, which is a wonderful thing. The third provision that is typical of association bylaws is holding harmless. Means that board members will be held harmless for their conduct within the scope of a board member if it's taken in good faith, right? That basically the membership will not be able to recover against you for doing that, right? Same thing, very similar to indemnification, defense, and hold harmless. Those three concepts go together. You'll also see provisions in your governing documents that use the word exculpation, which basically says that a homeowner cannot sue you for your service in good faith to the board. Now, I keep using the words for service in good faith. Keep in mind that if a board member does a purposeful wrongful act, right, or does something that is malicious and is not in good faith, the board member can be denied defense and can be denied indemnification and can be denied insurance coverage. So there are, you'll be shocked to know this because you're the good board members that turn out and do the educational seminars and so forth. But there are bad board members out there who will do bad things. And that can occur in a couple of different ways. Well, lots of different ways. It can occur in taking money, stealing money. But what we're seeing a lot of is in today's world where board members are at times acting in faith is, say, for example, attacking somebody or discriminating against people on protected class status. So a board member says, people of your type are never going to move into my community and I'm going to make darn sure of it, right? And people do say wacky stuff like that. You get sued for that and you actually act on those things, you will not be indemnified, defended, or held harmless. You will not be subject to insurance coverage either. So you have to be very cautious. As a board member, you have to do things within the scope of your powers as a board member. And then you also have to act in good faith. Okay, so that's very important. Third-party claims. Third-party claims are basically claims from non-board members. So all these indemnification provisions were written and anticipate that the board may be subject to what are generally called third-party complaints. So somebody trips and falls in the association, a member trips and falls and sues the association, sues its individual board members, sues the management company and says, hey, you should have maintained the sidewalk better. You left ice on the sidewalk and I tripped over it, I slipped over it, and I hurt my hip and you're liable for me. That's a third-party claim because it's not the board against the board or not a board member against the board. So that is generally how your governing documents are written. And that is what the intention has been, right? The language itself, often in the governing documents, can be somewhat unclear or ambiguous, and that was the case in the Boyle case. But let's talk about first what is a first-party claim. In the Boyle case, it was a first-party claim, so it wasn't somebody outside the organization suing the board members, suing the association. It was an actual sitting board member that had been removed, and then he was suing for wrongful removal. He was ultimately reinstated, and at the trial and appellate court division, he was awarded more than $563,000 in attorney fees and costs for suing the association and the board members. Which sounds insane, correct? Right? It sounds insane. Whatever lawyers they were, they made a fortune on this case, assuming they were paid. But $563,000. So at the trial level, the court awarded that money. The appellate division said, we agree. That seems right. The language in the governing documents does not carve out an exception for first-party claims. Therefore, we're going to give this guy, since he was a board member and he's fighting over his rights as a board member, indemnification, right? And everyone in the industry, I shouldn't say everyone, 95% of the people in the industry were shocked when the trial level and appellate court decision came down and said this guy gets $563,000 of his attorney's fees reimbursed for a number of reasons. Number one, I don't think anybody interpreted the governing document language that way. Number two, the dollar figure was just so huge, right? Just so huge. So I think that were the main things that really shocked people. It was totally unanticipated. So when we get to the bylaw language, the specific language in the bylaw is what governs. So if you're a board member and you have any question regarding indemnification, defense, or hold harmless, make sure you look at your bylaw provisions regarding that. And if believe it or not, there are some bylaws that don't even have indemnification, defense, and hold harmless provisions. If you have bylaws that are missing that language, make sure you speak to your association attorney and get that language inserted ASAP. And if it's unclear, make sure that language is clear. You know, even in the absence of language, there's arguments under the Nonprofit Corporations Act that you're entitled to indemnification, defense, and hold harmless anyway. But I would strongly encourage you to take a peek at your bylaws and make sure you find the language on board member indemnification, defense, and hold harmless. So language is important. The Nonprofit Corporation Act also speaks to this. Like I said, we're not going to go into detail in the Nonprofit Corporations Act because I'm going to try to move it all along today so that you can all get to your property inspections this afternoon. The D&O insurance coverage issue. Always, 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 if someone raises a written claim against a board member, the management company, the board, the association, you hear me saying this, I think, almost every time we have First Friday with Fran, make sure you put your carry-on notice on a timely basis of a threat. Hey, Carol, I don't like you, and you betrayed us as a board member, and I'm going to sue you. You get that in an email. Make sure you get that over to the association's insurance carrier promptly. Right? Because if you don't, and we've talked about this case that we had here in the past, the carrier can deny coverage based purely on the failure to timely notify of the threatened claim, right? And you don't want that to happen. We're talking about big money in terms of attorney fees alone, let alone potential liability, right? So it's very important to put the carrier on notice, the D&O carrier and your association's liability carrier. Sometimes there's a debate which policy will cover. Is it the D&O policy? Is it the liability policy? So when in doubt, put both on notice. So Boyle versus Ocean Club Condo Association, the 2023 case is there where the trial court and then the appellate court awarded Mr. Boyle the $563,000 for his attorney fees for trying to get back on the board. Okay, that was the shocking case. That was the lower level appellate division decision. And then we saw the 2024 case in Boyle versus Ocean Club reversed. I'm sorry, Mr. Boyle, you fought the good fight, but that $563,000 ain't going to be paid. You know, and the New Jersey Supreme Court is essentially the last stop on this type of case. It's not like you can appeal that to, well, you can try, but the United States Supreme Court is not going to take that. So Mr. Boyle, hopefully he was very, very, very wealthy, and he doesn't mind taking a $500,000 hit, but he's taken a hit. So that's really depressing for Mr. Boyle. What about, should we amend our bylaws, right, to address the Boyle case? Because there are some board members who say, you know what, we should have the right to sue the other members of the board and sue the association, and therefore we should expand the coverage of the express indemnification language in our bylaws to include first-party claims, okay? We would generally, this is not legal advice particular to your association, but we would generally very much advise against that, right? And there are lawyers who disagree with me on this, and some of them I know and I'm friends with. The main issue there is it goes against the general American rule where the people pay their own attorney fees, right? That's one. Number two, I think that there is a strong probability that it will encourage division in the board. It will encourage strong, aggressive division in the board. and it will foment litigation at the board level, meaning you will see more and more lawsuits by board members that are disgruntled against the other board members who perhaps are in the majority on the decision, right? So you have to be very careful. I know there are some people out there encouraging associations to amend their bylaws to provide this type of first party coverage. I don't think it's a good idea, and I would advise generally against it. So that's it very briefly. The one thing that I think everyone knows, right? It's a very, very hard insurance market right now, right? Your insurance policy premiums are probably going up upwards of 30% this year, right? And that is perhaps even if you have a nice loss history, right? You have very few losses, you have very few claims, etc. I can't emphasize enough how important it is to convey to the membership that when they do things like Mr. Boyle, and I'm not saying Mr. Boyle was right or wrong, I'm not taking a position on what Mr. Boyle did substantively, but when suits like this happen and you see these types of numbers in attorney fees, it is impacting the association tremendously, not just from the attorney fee standpoint, but tremendously from the insurance and the ability to get insurance in the future. Many, many, many association members do not understand that. And they routinely send, I got one this morning, they routinely send these emails that says to the board, and unless you do the following to the satisfaction owner before this date, we will sue you. Well, I have to advise the board to present that to their carrier. And the carrier is going to put that on the loss run, perhaps, oftentimes, yes. And what a lot of carriers will say is, you know, Fran, when this goes to underwriting, even though, Fran, you're telling me there was no major loss over the period of the policy, we do see notice, threat, small payout, notice, threat, small payout, notice, threat, small payout. And what that says to us, Fran, is that we can anticipate that there's a problem in that community and we can expect a large loss soon, right? So sometimes even when you don't have a history of large losses, if you have a lot of small ones, the underwriters will look at that and say, you know, it's just a matter of time before we get zapped. So when you get underwriting coming in, they may jack your insurance fees based on just that, even though you haven't had a huge loss. And I think it's really important for the board members and managers to continually send that message to the community. If you're constantly threatening to sue the board or you're constantly filing lawsuits, God forbid, you are impacting the association tremendously from a financial standpoint. And it's a financial impact that doesn't plant new trees, that does not upgrade your irrigation system, that doesn't get your roads paved. It makes lawyers rich, which I have no objection to in principle, but from an association standpoint, our goal for all of us is enhancement of the community, enhancement of community living, and trying to get along in a civil fashion. And the recent uptick, if you will, in incivility has generated some tremendous attorney fees and tremendous insurance losses. So that was really fast. I'm not going to, like I said, I'm not going to belabor it today. We will get to the mortgage foreclosure one next month. We do have some questions and comments in there in the chat. Not a lot, because I know there are some pretty heavy inspections this afternoon. So let's see. If a board member threatens to sue the board, but only verbally, would that warrant us reporting a claim? So, so Carol, I'm generally in favor of putting the carrier on notice. The real answer, though, is you should look at your policy. Some policies will say if there is a threat made in writing, okay. But again, my advice to associations generally is when in doubt, report, because if you lose coverage, you'll be paying out of your own pocket. So the case that I spoke about several months back was we had a case where the association did not timely report the claim. The association ultimately was relatively successful in having the claim disposed of through a nominal settlement. but we, as the association's general counsel, had to defend it. It wound over 2.5 years or 3 years, it wound up costing about $250,000 to pay us to defend it, which is a lot of money. And now the association is pursuing its former attorney because they claim their former attorney did not tell them to report it to their insurance carrier. We obviously don't have that case. We're not looking to sue attorneys if we don't have to, and that's not our practice area. But you don't want to get stuck with that type of claim. We have just been through it involving a different law firm, and you don't want it. So when in doubt, report. And your brokers can give you some insight on that too. So if you have, well, number one, take a step back. All of us, all these associations should be using brokers and carriers who are very experienced in the industry and who sit down with the board at least once a year, whether it's by Zoom or in person, and review insurance issues and coverage, right? Many associations don't do that, but I can tell you the professional insurance people in the industry that I know will be happy to do that. And it doesn't cost you any extra money. They're making their commission already. So you should sit down with them at least once a year, fire questions at them. Hey, if we have this type of hypothetical, should we report it? Put them on the line. What is new in the association world? Is this type of cybercrime covered? If the association's members' information got stolen from the management company and the members sue the board and sue the association, are we covered for that type of cybercrime? Is that cybercrime? Is that identity theft? Do we have proper coverage, right? Because insurance companies are coming out with new products all the time, especially in the cyber world. AI is going to make insurance much more complicated because we are going to see an uptick in cyber crime and theft. And between Mike and I, we've seen probably 3-4 cases of substantial theft from associations in the past several years. And you want to make sure that you're covered for that. Can't the DCA handle complaints prior to a lawsuit? Okay. So, Bill, yes, in theory, the DCA can handle some things. The DCA, I think, as I've said before, is well-intended. I think their heart's in the right place. I think they've made some mistakes with respect to the recent regulations. Nevertheless, I think that the DCA's heart's in the right place. But keep in mind, the DCA is not staffed to the point that it can handle all of the flow of association member and other complaints that come into the DCA. The DCA is not a bad place to start, though, and we work regularly with DCA reps. In the Boyle appeal, was the D&O carrier involved, or did they deny coverage based on the claim involving the plaintiff's attorney? My understanding is, and by the way, just so everyone knows, I was not involved in the Boyle decision. But my understanding was that the carrier was involved and there was insurance coverage in that case. What is a DCA? So, Carol, DCA is New Jersey Department of Community Affairs, and the New Jersey Department of Community Affairs is the regulatory body or the administrative body that implements, prepares and implements regulations under the statutes created by the legislature. So the legislature passes legislation. The DCA is the regulatory body that basically fleshes it out by passing regulations on top of the legislation. And then they do have a role in terms of enforcement and penalties and compliance at times. And now, honestly, the DCA has been taking a much more assertive role, a much more active role. And that can be good at times. It can also be bad at times. Dave Carroll says attorney fees, not defense fees. So, Dave, I believe that the D&O was involved on both ends of that case in an odd way because of the mixture of board member, non-board member, former board member, reappointed board member. So I think the D&O was engaged on both sides. So in an odd way, the D&O was, in theory, paying for coverage, defending the association's board members. And then, and again, because I wasn't involved in the case, I'm not sure of this. I think they were potentially on the hook for the 563. So they had potentially a loss on both sides of this lawsuit. And that's part of the reason why first person coverage is so wonky, right? As opposed to third party coverage, right? Insurance companies understand that they're on the hook for third party claims, but I would venture to guess that most insurance carriers, when they're underwriting these types of policies, are not collecting premiums based on the idea that first party claims would be covered and defended. Yeah, Department of Community does indemnification cover theft of a committee? Oh, so that's a good question. So Bill came up with a good question. Does indemnification cover theft of a committee such as the bingo committee? So if your bingo committee was running bingo and they were authorized a committee that was a part of the association, if you will, rather than something that was independent of the association, my guess would be, you have to speak to your broker, my guess would be that it would come under the association's policies if the association's theft policies provided coverage for that type of thing. Theft coverage can be very, very complicated, but you should have that type of coverage for any official association, board, committee, etc., especially any of those who are dealing with money. The one thing to keep in mind with most theft policies, and people don't realize this, generally speaking, with respect to a theft policy, and we've been involved, I may have told you this in the past, recently, we had a manager steal 450 grand and we had to pursue it, and we ultimately got it back through insurance. We didn't get it back from the manager. And he's ultimately, I think, going to see some time inside. But generally speaking, if you make a claim under your theft policy, the insurance carrier will require you to pursue criminal charges. And sometimes that surprise, it makes sense from an insurance standpoint, because otherwise there's the moral hazard of the association members and the thief colluding to saying, hey, Bob, you took some money from the bingo fund, but you're a nice guy, Bob. We're going to let you off this time. We're just going to make a claim on our insurance and we'll get the money back from insurance. The insurance carrier will say, no, that's not the way this works. You have to pursue them and you have to prosecute them and you have to cooperate in the prosecution, right? Otherwise, there's too much of a moral hazard. So you should make sure you have that type of crime coverage, because as many of you on this call, the association's board is handling tons of money, sometimes upwards of close to $10 million. So when you're looking at reserve funds and operating funds. So you should be reviewing your insurance every year, make sure the board members have proper indemnification, defense, and hold harmless, but making sure your whole insurance package is covering things as they come up in the new world order of AI, right? Because as we know, you could take a board member's voice sample with AI right now and direct it to a bank and have them direct a wire somewhere, right? So there's going to be more fraud rather than less in the near term, and we have to make sure that we're all protected from it and we all have proper insurance coverage. So that was pretty quick today. I hope everyone was fairly satisfied with this, and I hope you all get out there and hit the beach if it's warm enough. It's a little breezy, but if not, at least get outside. All right. So it's great seeing each other. As usual, it's wonderful to be here, and I really appreciate you attending. We really, 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 really appreciate you attending and participating. So have a great day. It's good to see you. Take care.